All right, perfect. Well, good afternoon, everyone. We appreciate you joining us here for Safety Week. Today, Rich and I, many of you may know us, are going to be performing a mock deposition for you guys. And we're going to be discussing the process of a OSHA inspection or an investigation after an incident, and how that will ultimately result in you being questioned, and how good preparation can ultimately protect you from the stress that comes from that process. So the first thing I want to talk about is some webinar logistics. All the participants here are muted upon entry of the webinar. There's going to be a question and answer box that you can access. And if you have questions, feel free to pop them up anytime. I have it up on another screen and we'll be happy to answer them as they come around. And there will be a Q&A session at the end. The presentation is going to be recorded and it can be distributed after the webinar if anybody wants to follow up with that. So many of you may know us, but my name is Joe Sine. I am a construction lawyer and the chair of our OSHA Compliance and Defense Practice Group here at Cohen Seglias.
And I'm Richard Sfraga. Good afternoon. I'm an EHS executive consultant at Signature Safety.
Just quickly about Cohen Seglias, we're one of the largest construction litigation firms in the United States. We represent currently over 1,500 contractors and other related construction companies such as subs or owners up and down the construction industry chain. We've tried cases in almost all of the 50 states and have approximately 90 attorneys across multiple offices up and down the East Coast.
And Signature Safety is a full-service environmental health and safety consulting company with offices located in New Jersey and Pennsylvania. We have the capability to serve all 50 states, and our clients span the spectrum of industries from warehousing and governments to construction subcontractors.
So quickly, where we're headed today in this presentation. First, we're going to help you understand or provide a reminder of the OSHA process that ultimately leads to interviews and depositions. Then we're going to provide some tips for depositions and interviews and how to effectively handle them. Then we're going to do a mock deposition after setting up a hypothetical safety incident to explain 3 different scenarios as to how you can help prepare yourself for that process. So to understand the process, you first need to understand situations and when interviews and depositions will arise. OSHA will create 2 opportunities for such an interview. The first is an inspection. OSHA does programmed inspections of sites, both construction sites and workplaces. They do targeted inspections aimed at specific high hazard industries. They will do inspections based on worker complaints or random programmed inspections as well. They will also do investigations to if there is a fatality or a workplace injury, and that's usually focused on identifying the root cause of that incident.
So when an OSHA inspection arises, first thing that happens is an entry and an opening conference. An OSHA inspector comes by. He'll explain the purpose of his inspection. They'll do a walk-around inspection. An employer and the inspector will walk the site and identify and document any hazards. The OSHA inspector will do interviews with key employees and managers, similar to a deposition. So you just have to be careful of what your answers are to them, and they'll document any requests. The inspector will ask for safety policies, training records, safety reports, things of that nature. And then there's going to be a closing conference. The inspector will discuss apparent violations, the employer's rights, and the citation process. Fallout for this type of OSHA citations: repeated violations, could be up to $161,323 per violation. Willful, also up to 161,323 per violation. Intentional disregard or just plain indifference. Serious violations up to $16,131 per violation. Serious violation shall be deemed to exist if there's a substantial probability that death or serious harm could result from that condition. Other than serious could be up to 16,131 per violation as well. And then de minimis, usually there's no fine with that. Both Joe and myself can represent you in those cases.
Outside of the OSHA context, the other circumstance in which a employee or managerial employee are going to be interviewed is in a deposition in connection with a personal injury lawsuit. So many safety incidents lead to costly and protracted litigation for your company. The deposition is the key tool that plaintiffs' attorneys use in order to create their case for trial. They will depose oftentimes many witnesses over a series of multiple days and will trigger their questions to elicit responses that will make settlement more difficult for you or your insurance carrier and will raise the value of that settlement as time goes along. Many of the plaintiffs' attorneys videotape these depositions now so that they can also, cross-examine you based on their demeanor and other information that is provided. I see that one question came in, is this being recorded? Yes, it is being recorded, and you can follow up afterwards if you want the recording. So if you're deposed in a personal injury lawsuit, it can often be an extremely stressful situation. As I mentioned, they can last for hours or sometimes days, depending on what jurisdiction you're in. There may or may not be a limit on how long they can depose you, but every question and answer can ultimately become key evidence at trial. So it's critical that you understand how to prepare for those depositions in order to effectively avoid liability. Generally speaking, the preparation starts well before the incident even occurs. Your company needs to make sure that they are properly documenting their efforts to comply with OSHA's policies and to protect their employees. Oftentimes employers will be stuck and shoehorned into bad answers based on plaintiffs' lawyers' questioning. And we're going to get into that a little bit later. Oftentimes when we talk about safety, we talk about it in platitudes as opposed to tools and training and mechanisms that you're using to protect your employees. And that's often a way that safety managers and other people at the employer's company can get themselves in trouble at a deposition. And we'll give you some examples of that.
Yeah, what's the solution to all of this? It's to make safety your number one priority. And that's why we're having this today during Safety Week. You should really develop and update your compliance safety programs, train your employees, enforce safety requirements on the job sites. So naturally, it's great to have all this documentation in place, but if they're not enforcing it at the job sites, you're going to have a serious issue. And protect your company by preparing now and not when it's too late.
Now I'm going to talk a little bit about some tips of the trade that we usually give our clients before they're going to be interviewed by OSHA or deposed by an attorney in connection with litigation. So generally speaking, at the OSHA interview stage, you want to be cooperative with OSHA and not combative. The CSHO who's conducting the interview, that's the Compliance Safety and Health Officer who's investigating or performing an inspection. They haven't decided yet whether they're actually going to be issuing a citation when they perform the interview. It's purely a fact-gathering process by the CSHO to assess whether a violation exists and whether a citation is necessary to create a compliant situation and deter conduct similar to that in the future. One critical point that I have to explain a lot to people is that OSHA has the right to issue their own subpoenas. So any relief you get from refusing to comply with a request is fleeting because they're going to issue a subpoena for those documents or that information. It's going to be enforced, and all you've done in the process is upset OSHA and get their ire. So you want to avoid that, and you want to be cooperative and give them the information. Being cooperative, however, doesn't mean that you're going to volunteer unnecessary information. When you're asked questions in an interview, you want to answer the question asked. Oftentimes, people feel like they need to get their story out or tell some story that's well beyond what OSHA is actually looking into. And it's important that you just answer the questions that are asked as they're coming along. You also need to prepare for that OSHA interview so that you know what potential violations could exist based on the incident or the inspection that occurred, and you can frame your responses in a way that sets up the defense for the future. A deposition is a bit of a different creature. When you're being deposed, the plaintiff's attorney is looking for any avenue to hold your company responsible. So you want to tread a little bit more lightly with your answers as opposed to the more free-flowing cooperative discussion that you have in an OSHA interview. The number one advice I give to every client is to always tell the truth at a deposition. A bad fact is much better than an uncredible witness. So if you're caught in a lie, it's going to taint every aspect of your testimony at a deposition, and that's the worst case scenario for a witness in your case. You want to prepare. You want to review the documents that you anticipate that'll be questioned at your deposition in advance and think about logically what your answer is and how to best frame that answer for your defense. It's important to note that the plaintiff's attorney isn't your friend. Many attorneys often use the "you get more with honey than vinegar" treatment and will lull you into a false sense of complacency. They're acting friendly, they're asking questions in a common manner, and it's meant to make you more comfortable and more susceptible to giving up more information that you otherwise might not. But with that in mind, you also don't want to be evasive. People who are evading questions and not answering the questions they're asked look guilty, right? So you want to answer the question directly that's being asked of you. You want to think about your answer before responding, and you want to give that clear, truthful answer in the best light for your company. And lastly, you want to give your attorney time to object, and you want to listen to their objections, as it can often help you understand what is problematic about the question being asked. Are they asking you more than one question, and is it compound? Are they asking you something that's really outside your expertise? Those are things that you need to think about before you answer. So now I'm going to toss it to Rich. He's going to lay out the
So a
hypothetical
hypothetical safety
scenario.
incident. One of the big ones for safety is a fall from height. We'll give you a scenario is an employee, we'll call him Bill, of a subcontractor, Subco, is installing exterior sheathing on the third floor of a commercial construction project. While working along the building's edge, Bill stumbled and fell approximately 20 feet to the ground below, suffering serious injuries from which he will never fully recover. At the time, Bill was working, the guardrails were removed, and Bill was not using a personal fall arrest system. OSHA then opens up an investigation on both Subco and its general contractor, we'll call them GenCon.
And then, the other piece of this is that Bill ultimately hires an attorney and files a personal injury lawsuit against Gen Con Subco and the owner. With that hypothetical common scenario in mind, Rich and I are going to play the role of various parties here to show you what the OSHA interview and personal injury litigation deposition may look like. The first hypothetical scenario we want to provide to you guys is an OSHA interview. So this OSHA interview is of Subco's superintendent, and it's by the CSHO that's investigating the incident to determine what the cause of it was. And in this series of questions, Subco's lack of safety documentation is going to become a focus of the concerns of OSHA. So I'm going to be asking the questions as the CSHO, and Rich is going to be answering them as the super for Subco. Does Subco have a fall protection plan?
No, no,
Does Subco have a written safety plan? If Subco doesn't have a written safety plan, how does it communicate to its employees any safety requirements related to fall protection on this project?
so if that question, let me go back to that question, sir. Did you ask me if Subco have any written safety plan?
I did, and what was your answer to
Yeah,
that?
yeah, no, we don't.
Then how do you communicate to your employees the safety requirements related to fall protection?
Well, we train them on the first day of work.
Is that training provided in a PowerPoint, a video, or recorded in any way?
Nope, nope.
Do you have any records that show that that training actually happened?
Uh, no, no, no.
Then how do you train them?
Well, it's my job as the superintendent to give them the overview. That's what we do.
And what do you tell them during that overview?
Uh, I tell them to use fall protection, and if they're working from height, they have to put a harness on.
Do you have any record that Bill actually received that training, such as a sign-in sheet or orientation agenda or even an email?
No, no.
Does Subco require its employees to carry OSHA 10 or OSHA 30 cards?
No, no. They can if they want, but no, we don't.
Did Bill have one?
I don't believe so. No.
Is it fair to say that Subco has no evidence whatsoever that Bill actually received any fall protection training at any point before working on this job?
I don't. I don't know.
So, under this scenario, with this testimony, is Subco going to receive an OSHA citation? You could all see the mannerisms that Rich was answering the question with and the way this interview was going, and it wasn't going well for Subco. Under this scenario, Subco's likely going to get 3 citations. One for failing to provide a training program for employees exposed to fall hazards. Another citation for failing to assure that the employees were training as necessary by a competent person. And likely a third citation for failing to initiate and maintain a general health and safety program. And it's important to note OSHA has incident by incident citation policies, which means while all 3 of these may seem like, really falling under one umbrella as a lack of training, you're going to be cited 3 times. And if there's more employees that were subject to this hazard, you might be cited more times. I've seen, upwards to 10 to 15 citations in one notice of citation before. So it's critical that you have these have your documentation in order.
So the takeaways from this is how to avoid these citations. You make sure you have a robust safety policies that are in place and that they comply with the OSHA standards. You train your employees on these company safety policies before they start working on the project, and document that the training took place. Sign-in sheets for the training, new hire orientations. Make sure that they sign those orientations. Keep records of what was included in the training and who provided the training, very important. Retrain those employees on a regular basis. And if they violate the safety company policy, you train them again.
So let's flip the script a little bit. It's the same subject matter, but let's imagine a world where Subco does have proper safety documentation. You know, they worked with Rich and I in advance and put together a plan and knew what they were supposed to do and put all of that together. Are they going to get cited for the same violations? And now I'm going to, you know, under that scenario, ask Rich similar questions. Rich, does Subco have a fall protection plan?
Sure. Yeah, we do.
Is that fall protection plan in writing?
It is. Yes.
Can you provide a copy of that to me?
Of course we can. Yep. You let me know when you need it.
Does Subco have a written safety plan?
Yes, we have a company-wide safety plan. A corporate HASP is what we call it, and a site-specific safety plan that it's actually applied to this project.
Did Subco train Bill on that safety plan?
We did, yes.
How so?
Well, on Bill's first day, like everyone else, he was provided a copy of the company safety plan and provided orientation on that plan. He signed the first page of the safety plan indicating that he received it, he reviewed it, and had training on it.
I'm going to follow up after this, but I'd like a copy of that documentation as well, and I'll request it within about 2 weeks, if that's okay. And what about this site-specific safety plan? Was Bill trained on that?
Yes, he was. Before anyone starts work for the day, I conducted a safety orientation, provided the plan, had them sign off on it, that they had received the plan and the training on it. And they had to attend the training course where the superintendent reviewed the safety plan with them and trained them on it. Yep.
And that training course, is that documented?
It is, yes.
So go ahead.
I'm sorry, he had the OSHA 30 training as well as his yearly training from our company on fall protection. That's documented with a sign-in sheet and a PowerPoint presentation. In addition, we had safety meetings called toolbox talks that everyone was required to attend, and where we discussed these issues. One of the topics we discussed was fall protection, and Bill attended that meeting and signed the sign-in sheet.
I'll follow up again for that documentation, but I think that's all the questions I have right now.
You got it.
So as you can see, in that type of interview, having all of the safety training, safety plans documented, and having records that the employees that you have out in the field actually performed all of that safety training is critical. It cuts OSHA's interview off at its knees and shows that you were actually complying with everything that you needed to out there in the field. We had a lot of discussion there about documentation as well. And generally what OSHA does is after these interviews, they will follow up with document requests and give you usually around a week or two to respond. The only documents that they demand immediately within 4 hours of the inspection are your OSHA 300, 301, and 300A logs. So those ones need to be maintained at the site and readily available for production when the CSHO follows up. But the rest of this documentation, it's important to know it before you walk into that interview, but you certainly don't have to have it all lined up and ready to go. We're now going to move into a discussion about poor on-site supervision, which can often become another subject of discussion at a deposition. In this scenario, it is a deposition in the plaintiff's personal injury case of Gen Con's safety manager. And safety managers often get deposed in order to tee up testimony about the critical nature of safety in construction sites, the need to comply with policies, and ultimately the hammer comes down if you fail to comply with those policies, and it can result in some serious liability if you haven't complied with those policies. So in this scenario, Bill sued Gen Con, alleging that their poor on-site supervision was at least in part the cause of Bill's fall and injuries. And Bill's attorney requested the deposition of Gen Con's safety manager, Ted. So in this scenario, Rich is going to play Ted, and I'm going to play the personal injury plaintiff's attorney. Good morning, Ted. How are you today?
Good morning. I'm very well. How are you?
How was the trip in? Was it nice?
It was okay. I had a little traffic here or there, but it wasn't bad.
Found parking okay?
Uh, eh,
Well, listen, we can validate that on the way out.
way and yeah, and then just coming in, but I'm here and we're ready to go.
Well, that's great. And we'll try to be, judicious with our time here and get you going, but we really truly appreciate you coming in. So the first question I want to ask you
Sure.
is, does Gen Con prioritize safety on its job sites?
Yeah, sure.
And you, as the safety manager, are intimately familiar with Gen Con's safety policies, correct?
Yep, absolutely.
How does Gen Con
Uh,
prioritize safety on its job sites?
well, Gen Con has a safety first policy, um, meaning it's the topic of every conversation in every meeting. Um, takes precedence over everything. Profitability, the start of the project, safety first. That's what we do.
And why does Gen Con have a safety first policy?
Um, because we want to make sure that our guys go home safe to their families. We have a we have a written policy that requires its supervisors to walk the site, perform daily checklists, to document safety hazards. That's what we do. To ensure that corrective actions are implemented. That's the safety policy we have in place.
And is that safety policy in writing?
It is, yes.
I'm going to show you an exhibit on your screen. Do you see this document in front of you?
It's a little small, but yeah, I can see it. Yep, yep.
And if we need to zoom in, we can. But do you recognize that document as a copy of Genco's safety policy?
Yes, for sure.
And you'll see that I highlighted a few portions that I want to talk to you about. Section number 1 is about the daily superintendent site walk. That's what you were just talking about, correct?
Yep, yep.
And it says the superintendent's going to conduct a comprehensive walk of the entire construction site at the beginning of each workday, correct?
That's what they do. Yes.
And that's something that you, as the safety manager, think is important to be done on all of Gen Con's projects, correct?
Yes.
And what's the purpose of that daily superintendent site walk?
Well, they want to make sure that if they see anything, they're looking to correct anything. They have a checklist and they make sure that they're doing any corrective action.
And that's section number 2 here, the completion of the daily safety checklist, correct?
Yes.
And that's the superintendent's obligation to complete that daily safety checklist, correct?
Yes.
And if we continue on to the third line of item number 2, what happens with the completed checklists?
Uh, they're submitted to me, and I take a look at them.
And why do you get a copy of those checklists?
Uh, to make sure that they're completed and that any remediation that has to take place, I make sure that it's taken care of.
And what is the superintendent and you as the safety manager, what are you supposed to do if a hazard is identified?
We immediately take care of that situation.
And is that policy supposed to be followed uniformly, or are there exceptions to that?
No, it should be followed uniformly, that's the way it's supposed to happen.
And that's so that you can protect your employees and consistent with your safety first policy. Is that fair?
Yes, yes.
Now, did Gen Con's superintendent perform a walk of the site on the date of Bill's accident?
So if I heard this correct, because it's a little spotty here, uh, what happened with Bill's incident? Did the superintendent perform a walk?
Correct.
So that's the question. It happened too early in the morning, and the superintendent didn't have an opportunity to complete it yet.
Well, was the superintendent on site at the time of the incident?
He was. Yep, he was on site.
So is it fair to say then that he didn't do the site walk, and I'm quoting your policy, at the beginning of the workday as required?
Yes,
And was the superintendent on site the day before the incident?
he was.
Did he prepare a daily safety checklist while performing his walk around that day?
I don't think he did. No.
So obviously on the date of the incident and the day before the incident, you as the safety manager weren't provided copies of those daily safety checklists because they were never performed. Is that fair?
Um, yes, fair.
Did you ever ask the superintendent why he didn't do the daily walkthrough and provide the daily checklist?
Well, he said he was busy and didn't have time for it.
Do you think being too busy and not having time to prepare the daily safety checklist is consistent with your policy of treating safety first?
No, no.
And you as a safety manager, when you failed to receive those daily checklists, did you do anything?
No, no.
Do you think you were making safety the number one priority when you failed to follow up to figure out why you weren't getting the daily checklist?
Could you repeat that again? I didn't hear it.
Yeah, do you think you personally were making safety a number one priority, as you testified before, when you didn't take any action when your own superintendent failed in this critical aspect of his job duty to provide you with the daily safety checklist?
No, no.
Do you know whether a guardrail was missing on the third floor the day before the incident?
I don't know. I don't recall.
Am I correct that Gen Con had a camera on the building across the street that took pictures of the project every day?
Yes,
I'm going to show you the picture that was taken the day before the incident. Take a look at this. Do you see the photo on your screen?
I see it. I see it.
Would you agree with me that the guardrail was not present the day before the incident based on this photograph? I'm sorry, your answer broke up there. What did you say?
I said yes. I said yes.
And if your superintendent had performed the site walkthrough and performed the daily checklist, is this an obvious hazard that he should have recognized and corrected?
Yes,
And did your superintendent have the authority to stop the work until the guardrail was put back in place?
of course, yes.
Isn't it true if your company did its job and went through the safety checklist and you did your job and made sure that that checklist was performed, that it should have identified the missing guardrail hazard, stopped the work, and Bill never would have been hurt?
I have no idea. I don't know.
You really don't know?
No, I don't know. I don't know.
That's the answer, and you're sticking to it?
That's my answer.
So, as you can see, that deposition did not go well for the safety manager. And one of the things you can see is the way that a plaintiff's attorney sets this up, right? He sets it up with softball questions to your safety manager about safety being a priority and a number one priority, and taking precedence over profitability because you want to send your employees home safely at night. Um, and then he comes in with the hammer and shows how your lack of diligence with respect to safety could have led to the incident itself. So in this scenario, how is a jury going to rule against Genco? Well, in a negligence cause of action, the question is, does Genco owe Bill a duty of care to keep him safe? If you look back at Genco's own policy that we showed, it said that the purpose of these daily site walks and checklists was to protect subcontractors and others from safety hazards on their job site. So based on their own words, they were taking on that responsibility. The second question the jury's going to have to answer is, did they fail to adhere to the standard of care of a general contractor under the similar situation? And based on the policy that they had written, it's going to be pretty hard to defend it, to say that a reasonably prudent general contractor wouldn't have taken action on those safety hazards as they existed. The last question is, was Genco's negligence a proximate cause of Bill's injuries? And that was really the key that I was getting to at the last question, that Rich, acting as Ted, was refusing to answer. And it's a question that you would have to ask yourself, right? But for Genco's negligence and failure to do the daily safety checklists, would Bill have suffered his injuries? Well, the situation was there the day before, and Genco did nothing to stop it. The next question, would it be foreseeable that Bill could be hurt if they failed to adhere to that standard of care? Bill is an employee performing work on GenCon's project site, and Bill is a exterior facade contractor performing sheathing work, and in doing that work, he is going to be near a leading edge. So I think, as it comes down to it here, the likely conclusion based on the testimony that Ted provided is that you're going to have at least a factual issue that a jury could award a judgment against Genco for failing to protect Bill from safety hazards.
Well, part of the takeaways is that, as you can see, Ted was anxiety ridden, right? So, um, besides the takeaways that you see on the screen, it's very problematic for someone that's being deposed and has to go through that situation where they're not prepared, where the company wasn't prepared. But also, you have to make sure that your superintendent and safety managers are following your company's safety policies. Make sure you're properly documenting the compliance with those safety policies. Company management, and a lot of times they don't. Company management should review any daily reports provided by on-site personnel and provide guidance to its employees on resolving safety issues in the field. Sometimes those documents, they die in the field. They don't get bumped up to management, and that's problematic. Management has a lot of, they have to give a lot of support to the field, and that's part of it. And if you observe the same violation 2 days in a row, you need to intervene immediately. Repeated issues show disregard for safety, compliance, and enforcement.
So let's talk about the deposition, the same deposition with the GC's safety manager, but there was quality supervision on the job site, and they were doing the right things. So I'm going to start asking Ted similar questions based on the safety policies. Does Gen Con prioritize safety on its job sites?
Yeah, sure.
How so?
In a number of ways. We develop safety protocols. We train the employees.
I think you froze, Rich.
I'm Ted.
Sorry,
I don't
Ted.
think I'm Rich. I'm Ted.
So
I'll,
I asked you
I'll
how
go
Gen
again.
Con prioritizes safety on its job sites.
In a number of ways. We develop safety protocols. We train the employees on the safety protocols. We enforce those safety protocols whenever we observe someone isn't following them, and then we retrain them.
Does Gen Con have a written policy in place that requires on-site supervisors to inspect the job site for safety hazards?
Sure. Gen Con has a written policy that requires its supervisors to walk the site, perform a daily safety checklist to document safety hazards, and to ensure that corrective actions are implemented.
Is this a copy of Genco's safety policy that you just referred to?
Definitely looks like it. Yep, for sure.
And this says that the superintendent is required to perform a comprehensive walk at the beginning of each day, correct?
Yes.
And the purpose of that is to identify existing and potential safety hazards. Is that fair?
Yes.
And the superintendent is required under this policy to complete the daily safety checklist at the beginning of the workday, correct?
Yep, sure.
And those are submitted to you as the safety manager, true? And why are they
Yes.
submitted to you?
To make sure that the checklists are completed and any remediation that's needed is completed.
And this policy, it also requires that hazards be addressed and mitigated immediately, correct?
Yes.
Did Gen Con superintendent perform a walk on the site on the day of Bill's incident?
No.
Why not?
Well, Bill arrived on the job site before normal hours without notifying Gen Con. The incident happened at about 6:30. The job site, we begin about 7 a.m. And right as our superintendent was arriving on site, the incident happened at 6:30.
So he didn't follow this policy and do a site walk at the beginning of each workday, correct?
Well, the superintendent was pulling into the parking lot at that point. So that's not correct. Gen Con's work had not started at that time when the incident took place.
Was the superintendent on site the day before the incident?
Yes.
Did he prepare a daily safety checklist?
Yes.
Were you provided a copy of that?
Yes.
Did you review it?
Yes.
Was there a guardrail missing on the third floor the day before the incident?
Nope. No.
Were there any times during this course of this project where Gen Con noted that the guardrail was missing?
Yes.
And when was that?
There was an incident noted in the safety document checklists where Subco was working without a guardrail in place. Trying to think of the date, but
Did Genco do anything to address it?
our superintendent stopped the work immediately. Retrained the employees on fall protection policy and immediately ensured that the guardrail was put back in place as required by our safety policy. He then noted on the report that it was corrected and provided a photograph with the daily safety checklist of both the condition before the repair and after the repair. After all that was completed, our superintendent also held a toolbox talk, or what we would call also is a safety stand down, the next day to explain to all the subcontractors on the site the importance of following the fall protection policy.
So you can see from this deposition, this is a prepared general contractor who adheres to its own safety policies. They have a daily safety checklist performed. They're performing the work on the site. They're documenting when there's issues, and they're immediately taking corrective action. If you do that, the fact that there was a guardrail missing on one day is actually a helpful fact for you in this situation, because you as the general contractor exercised your discretion, found the safety hazard, documented the safety hazard, immediately corrected it, and documented the way that you corrected it, and retrained all of your subcontractors to make sure you were doing the right thing. So what would the reasonably prudent general contractor do? Just what Gen Con is doing in this situation. And this makes it very difficult for a plaintiff's attorney and any potential safety expert they hire to claim that you as the general contractor weren't following your own policies and following the general industry standards for what a safe and prudent general contractor would do. Now we're going to move into the third aspect of our mock depositions, and that is scenario 3, which is the enforcement of your safety policies. While many contractors have great policies and maybe even great supervision to make sure a safety incident doesn't take place, where they fail to close the loop is in the enforcement of their policies. So through this example, this is going to be Subco's OSHA interview, the same superintendent that Rich was playing in our first scene, who's being interviewed by the CSHO, me, as part of OSHA's investigation. And in this scenario, it's going to focus primarily on Subco's enforcement of its safety policies. Rich, does Subco have a safety plan?
Yes, in fact, we had a site safety plan that was specific applied to this project.
Did you have a fall protection plan in place?
Yes, it did.
Did you provide Bill training on that fall protection?
Yes, we did.
How so? I think you froze. How did you train Bill on the fall protection plan? Did you document the training of Bill on the fall protection plan?
Yes, we did. We have a sign-in sheet that shows who was in attendance and a copy of that PowerPoint.
Does Subco's safety plan have an enforcement policy?
Yes, it does.
Does your superintendent monitor compliance in the field?
Yes.
How so?
He walks the site and fills out a daily checklist and identifies any issues on site.
And what does he do if he sees an issue?
He gets it corrected.
I'm showing you a document. Is this a section of Subco's enforcement policy in its safety plan?
Yes. Yeah.
And how does this work?
Well, like a lot of companies, it's a 3-strike policy. The first strike is a verbal warning and retraining. The second strike, you're sent home without pay and receive a written warning that goes into your personal file, and you have to retrain. The third strike is you're dismissed from the company.
And how long have you been a superintendent for Subco?
About 20 years.
Have you ever dismissed an employee after they got the third strike under this policy?
No.
Have you ever sent an employee home for failing to adhere to the company's safety policies?
No, no.
Have you ever followed the first strike and given a verbal warning and forced retraining?
Uh, if you're asking, have I provided any verbal warning? Um, Forced people to retrain? Is
Yes.
that it?
Yeah, in compliance with the first strike of this policy.
If I'm sorry, could you just repeat that one more time?
Sure. Have you ever provided verbal warnings when you observed safety hazards to your employees and forced them to retrain on those safety policies?
Okay, now I understand. Yes, I have.
Now, so I see that you've followed strike one, but never two and three. Is the reason you've never followed up with strikes two and three is because Subco's employees have never committed a second safety violation?
Uh, I don't know. I don't know.
Do you know if you've ever seen the same employee commit the same violation more than once on a project?
I don't know. I don't know.
Do you know if that happened on this project with Bill?
I don't know. I don't know.
Rich, you're the superintendent for Bill. If you don't know, who does know?
Um, I don't know.
Is this a copy of a daily safety checklist that was prepared by Subco?
Yes,
And is this dated April 1st, so several weeks before the incident?
yes.
And I'm going to draw your attention here to the middle of the page. What's the observation related to fall protection?
It says I observed that an employee was failing to wear his personal fall arrest system.
And who was that employee?
Um, Bill Smith.
The same Bill Smith who was injured in this case?
Yes.
And what action did you take as the superintendent responsible for Bill's safety?
Um, I, 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 I explained to him that there was a need for a personal fall arrest system.
Did you
That was
provide
my training.
retraining? So you followed the first strike in your policy. Is that fair?
Pretty much, yes, pretty much.
What records do you have of the retraining you provided to Bill?
Um, None other than the reference on the document, to the on-the-spot training in the field.
And what do you mean by on-the-spot training in the field? What is that?
Like I explained it to him in the field. I told him in the field what he needed to do. That's it, on the spot, like right there.
This is a daily safety checklist from 2 weeks later prepared by Subco, correct?
Repeat that question, please.
This is another daily safety checklist from April 15th, about 2 weeks later, correct?
Yes.
And if I draw your attention to the safety checks, was an issue with fall protection noted?
If I understand the question correctly, it says that I observed an employee that was wearing that was failing to wear his personal fall arrest system.
And who was that employee?
It was Bill Smith. It was Bill.
So this was the second time in 2 weeks you observed Bill failing to adhere to the company's fall protection policy, correct?
Yes.
Did you give Bill a written warning and send him home for the day consistent with the safety policy?
Uh, no, we're very busy. No.
Why not?
We're busy. I don't know. I don't. We're very busy. Busy project.
So you have an enforcement policy in writing, but you don't actually follow it when you get busy with construction. Is that fair?
In this instance, that might be correct.
And you don't recall a single instance in your 20 years as a superintendent for Subco where you ever followed that policy. Is that correct?
Yes.
So, as you can see, Subco in that situation is likely going to be cited for failing to enforce its safety policy. The most common OSHA defense that we see is called the isolated employee misconduct defense. And one of the elements of that is a requirement that you show that the employer actually enforces its safety policies. In this circumstance, because the company failed to actually enforce those safety policies, they'd be unable to avail themselves of the defense that this was isolated employee misconduct because Bill had been trained and the company enforced those policies uniformly. So it's really important to make sure that you're enforcing those policies as they go along. So let's flip the script a little bit, right? The same enforcement policy, but Subco actually does enforce it. Let's see how that goes. Rich, is this a copy of Subco's enforcement policy?
Yes, it is.
Can you explain to me how it works?
Well, it's a three-strike policy. The first strike is a verbal warning and retraining. The second strike, you're sent home without pay and receive a written warning that goes in your personal file, and you have to retrain. And then the third strike is you're dismissed from the company.
And how long have you been with the company?
20 years.
Have you ever dismissed an employee for getting its third strike?
Yes.
How many times?
Twice. Remember it well. Twice.
Have you ever sent an employee home for failing to adhere to the safety policies?
Yes.
And do you know how many times you've done that?
Um, Off the top of my head, I would say at least 5 times that I could remember.
Do you know if that happened on this project?
If you're asking if I know if this happened on the project with Bill, yes, he was actually on the second strike at the time of the incident.
And explain to me how that came to be.
We first observed Bill violating the fall protection plan by failing to wear his personal fall arrest system on, I think it was April 1st. I noted it in my daily inspection report and noted that I provided the verbal warning and retrained him.
And let's stop right there. How did you retrain him?
I brought him back to the job site trailer, sat him. He'd like,
And what happened to get the second strike?
what happened to get the second strike?
Yep.
2 weeks later, I observed the same problem.
Then what did you do?
I documented it in the daily checklist. I sent him home. I gave him a written warning, and I sent it to HR to place in his file. I'd be happy to ask HR to send you a copy if you'd like. Then once he returned the next day, I retrained him again.
And we're gonna skip some of this, but as you could see, during that deposition, Rich was much more prepared to answer the questions about the enforcement policy and actually showed that Bill was failing to adhere to the company's policy and had been given 2 steps of the warnings and that it had been properly documented. This is powerful evidence for isolated employee misconduct. It shows that you're enforcing it even on this job and with the particular employee at issue. And it shows that this employee may have been reckless and at fault for his own injuries. So under this situation, Subco will have a much better opportunity to use the isolated employee misconduct defense because it did all of the things that we talked about today. It had a written policy that required the use of fall protection. They trained their employees, including Bill, on the fall protection and had documentation on it. They enforced their safety policies through warnings, retraining, and sending non-compliant homes from work. And ultimately, the incident occurred before the superintendent was present because Bill started working before he got there. So again, it is critically important that all three of the pieces of the pie that we put together today, you follow down the line. So some takeaways from this. The written policy that you have is only as good as its enforcement. Otherwise, it's not worth the paper that it's written on. You need to document that you're enforcing your safety policy, because if you can't document that, you can't prove to others that you followed through with your safety plan. You also need to retrain employees if you observe them violating your company's safety policies. And it's important to note that it often only takes one or two examples. If you have to terminate an employee, the employees will then realize that you're serious about your safety program, and the next guy will think twice before failing to put on his hard hat or goggles the next day. So just in conclusion, just remember, depositions and interviews are stressful, even under the best circumstances. So you need to do your work ahead of time. And if you do that, it'll make them much less stressful. You need to make sure your company's safety documents are compliant. You need to make sure that your projects are adequately supervised and your supervisors understand the importance of the documents and the enforcement obligations that they have. You also need to review the project-related safety documentation before you walk into a deposition or an interview, so that you can converse in a conversational way that puts your best foot forward for the case. And avoid complacency in an interview or a deposition. They're not your friend. They're there to do a job, which is to assess whether you were doing your job and enforcing your safety policies. So we're going to open it up to questions now. I know we're a little bit over time here, so if people want to hang around and ask a few questions, Rich and I are here. I see several questions were asked about the recording and Rich's screen freezing. There were a couple technical issues, so we apologize for that. But thank you all for your time today. Rich and I truly appreciate it, and wish you all a safe safety week.
Have a great week, everybody.